My name is Doug Tennant. I'm with Veterans Legal Institute. I'm a senior staff attorney. I work in various areas of the law, including veterans benefits, which is our topic today, disability compensation claims with VA. Today's program does not provide legal advice. Today's program is a general overview, and for any specific circumstance, you should consult with an attorney or a VA accredited claims representative. In today's program, we will learn about elements of a claim for VA disability compensation, the types of claims, the ways to prove a claim, and how to file a fully developed claim. Disability benefits compensation. There are three specific elements that need to be satisfied before a veteran may be awarded VA disability compensation. 1, a current disabling physical or mental condition. 2, the condition must have been incurred or have been aggravated during military service. Number 3, a veteran must show a nexus, that is, a connection between the current condition and the in-service incident, event, or illness. Types of claims. There are two basic types of claims: a new claim or a supplemental claim. A new claim is one you've never filed before, or a claim for an increase in the rating. That is filed on a VA Form 526EZ. Second type of claim is a supplemental claim. This is for a claim that was previously filed and previously denied. And we'll discuss the aspects of the supplemental claim in more detail. Special requirement for claims based on mental health. We'll cover this in more detail. Whether it's a new claim or a supplemental claim, you must file a VA Form 210781 or 210781A for a claim that involves a mental health condition, including PTSD or MST. New claim. A new claim requires a current diagnosis of a physical or mental condition, an in-service event that led to this physical or mental condition or symptoms of the condition began or manifested in service. And then there must be a nexus or relationship between the in-service event and your current condition. This is an important third element. You have to have a current condition, and you have to have an in-service event and a connection between the two. Usually a doctor's opinion obtained by the VA is one of the ways that the nexus is established. Or it can be provided by your own doctor. You can also use medical literature to show a relationship. The VA requires a new claim or a claim for an increase in rating to be filed on a Form VA 21526EZ, Application for Disability Compensation and Related Compensation Benefits. You can find this form and all other VA forms at va.gov and download it, or you can submit it online through eBenefits. A supplemental claim, that is a claim that was previously filed and denied that you want to pursue, you can continue to pursue the claim by filing a supplemental claim. Under the Appeals Modernization Act, there are actually 3 paths once a claim has been denied. A veteran can continue to pursue the claim by an appeal to the Board for Veterans' Appeals, and that's an appeal heard by an administrative law judge. Or 2, you can request a higher level review, which is an expedited review to a VA regional office employee, and there's a separate form for that. Or 3, what we're covering today, which is by filing a supplemental claim. With a supplemental claim, you must provide new and relevant evidence. That's an important standard. You can't just submit the same information that you had before. You have to submit new evidence. That's evidence that the VA had not seen before. And relevant evidence, that's evidence that rebuts the reason the VA denied the claim. Evidence examples. medical evidence with a current diagnosis, a buddy statement that you never submitted to the VA that supports the claim of an in-service event and the resulting diagnosis. Newspaper articles of events can be helpful to prove an event happened. Where to start? When you're going to prepare a supplemental claim, begin with your decision letter that denied the claim and read the VA's reason for denying it. Here's an example. The VA denies your claim because there's no current diagnosis of a back condition. You can provide medical records of your back condition. You can provide a statement that describes your back pain and the severity of your back condition. Here's a decision letter example. Service connection for low back pain with scoliosis. In here it says, the evidence does not support a change in our prior decision. It says, a disability which began in service or was caused by some event in service must be considered chronic before service connection can be granted. Although there is a record of treatment in service for low back pain with scoliosis, no permanent, residual, or chronic disability subject to service connection is shown by the service treatment records or demonstrated by evidence following service. We did not find a link between your medical condition and military service. So they did have favorable findings. The evidence shows that a qualifying event, injury or illness, injury or disease had its onset during your service. Your service treatment records show that you were seen for low back pain while in service. And currently, on your most recent VA examination, you had a diagnosis of lumbosacral strain. But the VA is saying you did not have a connection. It was not chronic. And this is one of the harder aspects to try to establish the connection between your service injury and your current condition. If you have medical records, if you have family statements, if you have evidence that you lost work, the longer the time is between time of service and the time of your current claim, the harder it will be to satisfy this connection. A doctor is, if your doctor will step up and submit a nexus letter, that will be extremely important. Supplemental claim, you file it on a VA form 200995. You have to list the specific issues that the VA previously denied and the date of the decision notice. One line per. So you can do a supplemental claim that covers more than one issue or more than one denial, laying them out on separate lines. Claims based on mental health, whether it's a new claim or supplemental claim, claims for PTSD and MST require you to file a form VA 210781 or 210781A in addition to 526EZ new claim form or the 200995 supplemental claim form. These forms help the VA identify the unit you were with when the incident happened, provides time frame that the incident happened. The VA will review your file for corroborating evidence such as changes in your performance and service treatment records. Ways to prove a claim. VA claims can be established using 5 different theories. Direct service connection, secondary service connection, aggravation, presumptive service connection, and VA medical malpractice. Direct service connection, the basic premise is you must prove your current disability is directly linked to the in-service incident. So if you choose this path, your greatest challenge is you must prove chronicity, aka the continuity of symptomatology, going back to the back condition, a back disability where you left the service with extreme limitations in your mobility and under a doctor's care, and you continue to be in a doctor's care, would make the establishment of the continuity or the direct service connection fairly easy to prove. But when you have 10 or 20 years between separation and your current condition, challenge will be proving the continuity of symptomatology, proving that you had care or why you didn't have care and that you were still having symptoms, that you were limitations and it was affecting your life. The example we're using here is you injured your back during a car accident in service, and you need to show the continuity of the symptoms from that. Secondary service connection. That is where a disability is caused or aggravated by an already service-connected condition. So once you have a condition that is service-connected, you can try to service-connect other conditions that are secondary to, caused by, resulting from the already service-connected condition. The greatest challenge here is you must prove that the service-connected condition, at least as likely as not, caused or aggravated the new condition. You have a back problem from your car accident during service, you get that service connected, you develop neck and hip pain afterwards, and you have problems in your movement and you're limited in your ability to work because of your neck and hip pain that was secondary to your back injury. Aggravation. Aggravation is another concept. This is where you may have entered the military with a condition or disability that began before active duty but was made significantly worse during military service. The greatest challenge here is you must prove that the military service aggravated the natural progression of the condition. This can be done for some conditions, injuries, illnesses, but for others that are congenital, it's a much harder burden to prove. The example again, you injured your back prior to service. Your back pain worsens and becomes severe after an accident in service. You may be able to establish aggravation of your pre-existing back condition during service and service connected that way. Presumptive. Presumptive service connection. The law will presume service connection and not require you to prove it with respect to certain types of illnesses and other disabilities. For example, you served in Vietnam and you were exposed to herbicides like Agent Orange. You later developed ischemic heart disease, coronary artery disease. The VA will presume that your ischemic heart disease is connected to your service in Vietnam. Number 5, VA malpractice. If the veteran is disabled or dies as a result of malpractice during VA medical care, the resulting disability will be treated as if it is service-connected. A claim of VA medical malpractice, a so-called Section 1151 claim, is incredibly complicated, incredibly individualized, and difficult, requiring knowledge of applicable state law. A veteran should talk to an experienced VA medical malpractice advocate. How to file a fully developed claim. The veteran should include evidence of diagnosis, in-service event, and nexus, the 3 elements of the claim. Veterans should provide a statement in support of claim. There's a VA Form 21-4138. Statement in support of claim will describe when the event happened and how it happened, whether the veteran got treatment while in service, if not, why not, how the disability affected the veteran after service. Did the veteran get treated for it after service? If not, why not? How the disability affects the veteran today. Has the veteran stopped the activities that the veteran used to do? Has it affected your ability to work? Describe how you are limited in work and at home. You can describe pain, limitations of movement, inability to perform work, functions, etc. Remember that after the VA service connects you, the rating percentage will be based on severity, chronicity, and frequency of symptoms, and impairment, how it impairs you in work and social functions. You should also provide buddy statements containing evidence. These go a long way to support a claim. An example of that would be veteran is claiming tinnitus. Veteran and buddies used to complain about the noise levels that they were exposed to on a constant basis and how they had buzzing in their ears. Those are helpful. Family member who knew what you were like prior to service. Now, when you have a claim like PTSD, that it can be very important. Buddies who served with you and saw you injure yourself or know of the injury. For example, the back injury that we've used as several times an example. You were a combat medic. You had to pick up a 80, 100-pound bag and carry it in under extreme conditions, and you complained but didn't seek official service treatment because you treated yourself. You're a combat medic. Friends and family who know how your condition bothers you today, or the course of your condition. Again, the back injury, how many times you'd be laid out with your back problems, miss work, miss family events. Same for other types of conditions. Provide medical statements or literature to support the claim, especially where you may have a claim that is not presumptively connected to something like Agent Orange exposure. Sometimes you need to have scientific literature to then support your individual circumstance for direct service connection. Also, medical statements from doctor that describe your symptoms, describe your limitations, and describe the connection between your service and your disability. What you now know. The elements of a claim for VA disability compensation require evidence of a current diagnosis, in-service event or condition, and a nexus, that is a connection between the current condition and service, and evidence of severity of impairment in both social and work functions. You've learned about types of VA claims. There's a new claim or a claim for increase that will be filed on a VA Form 21526EZ. A supplemental claim that will be filed on a VA 200995 which requires new and relevant evidence after denial of an initial claim or a previous supplemental claim, or after denial of an appeal. As we discussed in brief, under the Appeals Modernization Act, there are three options after denial of a claim: an appeal to the Board for Veterans' Appeals, a higher level review, or a supplemental claim. We learned the ways to prove a claim: direct service connection, secondary service connection, aggravation during service, presumptive service connection, or VA malpractice. We also learned what you need to include in your claim. 1, a VA form for initial claim or supplemental claim, veteran statement, buddy statements, and documents in support of the claim, and medical evidence. Today's presentation has provided just a basic introductory overview concerning VA disability compensation claims and the elements of those claims, some practical thoughts. It is not a comprehensive discussion, and it does not provide legal advice. VA disability compensation claims are an important area where veterans require assistance. If you are an attorney who is willing to serve our veterans who've served our nation on a pro bono basis, please reach out to Veterans Legal Institute at www.vetslegal.org. We will provide additional information, some training, and we will be grateful for your assistance.